Fellow law teachers, in my previous lecture, I discussed the relevance of labor law, how to achieve high standards, how to create and retain the interest in the class, how to divide and demarcate lectures, and what should be the method of teaching. We now propose to take up, by way of illustration, as to how I have dealt with the statutory definition of retrenchment and its interpretation by the Supreme Court. Prior to 1953, the word retrenchment, as you are aware, was not defined in any legislative enactments in India. It was in 1953, by amendment, Section 200 was inserted in the Industrial Disputes Act, which defines retrenchment to mean a termination of service by the employer for any reason whatsoever, otherwise than punishment inflicted by way of disciplinary action. But it doesn't include voluntary retirement of the workman on reaching the age of superannuation, termination of service of the workman as a result of non-renewal of the contract of employment between employer and the workman concerned, on the expiry of such contract being terminated under stipulation in that behalf. And lastly, the termination of service of the workman on the ground of ill health. The definition which I mentioned here, according to me, is very badly drafted, for there are inherent contradictions in the definition. If retrenchment means termination of service by the employer, then what about voluntary retirement of the workman, which is certainly not termination of service? Similarly, the retirement on reaching the age of superannuation is not a termination of service unless it is considered to be a formal act of the employer to remove the name of the workman from the muster roll. Here one fails to understand the purpose of the exclusionary clause. Notwithstanding the contradiction in the definition, it is interesting to note that the legislature intended to interpret the definition in its widest possible manner. But in Barsi Light Railway Company versus Joglaikar, which was reported in 1957, while interpreting the aforesaid provision, the court interpreted the word for any reason whatsoever to mean for any reason which is connected with economy, whatsoever the reason may be, and thereby restricted or curtailed the scope of the term retrenchment. But the Supreme Court in 1976 in State of Bank of India versus Sundaram and Hindustan Steel Limited versus State of Orissa, likewise in Gujarat Steel Tubes, they made a departure from the Barsi Light Railway Company and rejected the ordinary accepted connotation of the term retrenchment. The court gave a very wide meaning to the term retrenchment. The consequence of this interpretation is far reaching. It would render the word discharge in section 2A superfluous, introduce anomaly in the application of section 11A, 25G, 25H, and 33, and thereby threw the schemes of the Industrial Disputes Act out of gears. However, according to me, if this view is accepted, management would be forced either to dismiss or retrench the workers in case of loss of confidence or strained relations between employers and workmen, on termination of or even on abolition of the post. And even in case of the labor employed on contract work of temporary nature or seasonal character. Indeed, it would be anomalous to the point of absurdity and would result in horrifying situation if the employer who terminates the services of his workmen for loss of confidence or inefficiency or insubordination and the like is compelled to re-employ that very workman in the same industry or business, and that too in preference of other workmen whose services are not terminated for loss of confidence, inefficiency, or insubordination. It is felt that Bersilite Railway Company on the one hand and Sundramani, Santosh Gupta, even Gujarat Steel Tubes on the other, took extreme views in the matter. If the former, namely in Bersilite Company, unduly restricted the coverage of the retrenchment, the later decisions such as Sundramani, even the Gujarat Steel Tubes, etc., give a wide meaning and thus threw the revised scheme of Industrial Disputes Act out of gears. Further, the consequences of reopening of the issues after several amendments in the Industrial Disputes Act are tremendous. Before we conclude the discussion, I think one may refer that even Surendra Kumar versus Industrial Tribunal, the court was in a position to note down and it wrote and it was inclined to disagree with the decision of Santosh Gupta. Having discussed this aspect, we turn to discuss how cases should be selected by teachers. I personally feel that cases be selected as per their importance. It is difficult to cover in a limited time at our disposal, even all important cases. Old cases which have lost importance may be omitted. So also many new cases that do little more than to repeat the old doctrines may be ignored or may be omitted. It doesn't mean, however, that every labor law teacher would select the same case, but is felt that most of them, if not all, would like to teach leading cases, particularly the epoch-making judgment. For instance, I would like, depending on the time allotted to me, to discuss the following leading cases in labor laws along with the new cases. Now let's my starting point is about labor and constitution. Here one may wish to include the Bharat Bank versus their employees, which was the first case of the Supreme Court, I must say, a most important one, and an epoch-making judgment which is reported in 1950. Then we have the People's Union for Democratic Rights versus the Union of India. And the third case, which one may wish to include, is on Vishakha versus State of Rajasthan. Then on the definition of industry, we have a leading case where the Supreme Court made an innovation, and that is Bangalore water supply versus Rajappa. On service contract and standing orders, one may prefer to include Delhi Transport Corporation versus DTC Mazdoor Congress, which was reported in 1991. On contract labor, we have the Constitution Bench judgment on Steel Authority of India versus National Union Waterfront Workers. On child labor, we have a very important judgment which was rendered in MC Mehta versus Union of India. Likewise, on a minimum wage, one may wish to include the Workmen versus Management of Reptox, Brett and Company. Likewise, on right of the casual daily wages or temporary or contract or ad hoc employees, one may consider to include State of Karnataka versus Uma Devi, Gujarat Steel Tubes Limited case. Likewise, on retrenchment, one may consider the Bharat Sanchar Nigam case, which was reported in 2014. On right to strike, one may wish to include Rangarajan versus State of Tamil Nadu. Then on Employees Provident Fund, we have a judgment which is reported in 2019 in the Regional Provident Fund Commissioner versus Vivekanand. On Factories Act, we have a recent judgment of 2020 in Gujarat Mazdoor Sabha versus State of Gujarat. Now let us see how I have dealt with some of the cases, and I would like to take only a few instances in my book. Coming first to the government servants' right to strike. One of the leading judgment is T.K. Rangarajan versus Government of Tamil Nadu, which was reported in 2003. Let us start with the factual background. In this case, the government employees, including the teachers of government-aided school and colleges, went on an indefinite strike in pursuance of their demands relating to pension benefits that has been curtailed on the grounds of resource crunch. The government of Tamil Nadu first invoked the Tamil Nadu Essential Services Maintenance Act, and then promulgated an ordinance empowering itself with the power of summary dismissal in mass without giving the employees an opportunity to be heard. Accordingly, the government summarily dismissed about 1.7 lakhs government employees, including the teachers, for participating in a strike. The employees were stopped from resuming their duties. And quite apart from this, 2,211 employees and their leaders were arrested and FIR were registered for inciting the strike. Aggrieved by this decision, the employees filed a writ petition before the Madras High Court. The single judge of the High Court, by an interim order, directed the state of Tamil Nadu to keep the suspension and dismissal order in abeyance until or say till further orders. Then it ordered to permit the employees to resume their duties. Aggrieved by this order, the state of Tamil Nadu filed an appeal before the High Court. A division bench of the High Court made certain observations which I will discuss. But in the meantime, a public interest litigation, or PIL, what you call it, was filed on behalf of the employees, wherein the validity of the Tamil Nadu Essential Services Maintenance Act and the Tamil Nadu Ordinance number 3 were challenged. Be that as it may, the division bench of the High Court set aside the interim order issued by a single judge, and he directed the state government employees to approach the state administrative tribunal. The court also directed that those who were arrested and lost in the jail be released on bail. Against this order, the employees filed an appeal before the Supreme Court. The writ petitions were also filed before the Supreme Court for getting the same relief. Having discussed this background, I now come to the area of conflict. The Supreme Court was called upon to decide several issues. One of them was there any justifiable reason for the division bench of the High Court not to entertain the petition on the ground that the petitioner did not avail the alternative remedy provided under the Constitution and the statute? The second issue was, is there any fundamental right to go on strike? The third issue was whether government servants have a right under any statute to resort to strike. Fourthly, the question arose, is there any moral or equitable justification to go on strike? And lastly, whether the Tamil Nadu Essential Services Maintenance Act and the Tamil Nadu Ordinance was violative of the provisions of the Constitution. Let's take the first question about the powers of the High Court to exercise its extraordinary jurisdiction. The Supreme Court examined the order of the division bench of the High Court that the writ is not maintainable because an alternative remedy was available to them, which they have not exhausted. The Supreme Court found that such refusal to entertain the writ petition is legalistic, particularly in an extraordinary situation where the government of Tamil Nadu dismissed over 1,70,000 employees, and the Tamil Nadu State Administrative Tribunal is almost defunct, and it was only one vice chairman to run it. The court remarked that it is unfortunate that the concerned authorities are not making the administrative tribunal under the Administrative Tribunals Act functional and effective by appointing men of the caliber. Having said so, the court also conceded that no doubt it is true that the Supreme Court in L. Chandra versus the Union of India held that it is not open to the employees to directly approach the High Court even where the question of statutory legislation is challenged, but added that this ratio should be read in the context of the question, which was to be decided. The court also held that the, the court should exercise its function, particularly in such a situation. Then the court dealt with whether there is a fundamental right to strike or not, and Supreme Court, as you are aware, that even in All India Bank employees case and Commissioner for the State of Bihar and other cases, the Supreme Court ruled that there is no fundamental right to strike. Then the court examined whether there is any statutory prohibition on the government servant to go on strike. The Supreme Court, in this regard, responded by observing that there is no statutory provision which empowers the employees to go on strike. On the other hand, there is a prohibition to go on strike under the Tamil Nadu Government Service Conduct Rules, which provides that no government servant shall engage himself in strike or incitement thereto or in similar activities. Having said so, the Supreme Court began to discuss whether there is a moral or equitable justification to go on strike. Now, in this regard, the Supreme Court proceeded to determine the issue whether there was a moral justification. The court added that even if there is an injustice to some extent, they have to resort to machinery provided under different statutory provisions for redressal of the grievances. I had an opportunity to examine this decision, and this decision raises a basic question whether it was necessary to decide the issue of moral or equitable justification to go on strike when it had already held the strike to be illegal. This is all the more so when the court, following its earlier decision, ruled that strike is not a fundamental right and government servants do not have any legal right to go on strike. It is submitted that there is no need to decide such a question, particularly when the Supreme Court in General Navigation and Railway Company versus their workmen, reported in 1960, held that strike, which is illegal, cannot be characterized as justified. But there is yet a positive role which was played by the Supreme Court. And I must say it was a constructive role or even a conciliatory role which was played by the Supreme Court by easing the situation. And in this process, the court succeeded in getting the undertaking from the government of Tamil Nadu to employ a, most of the employees, except those against whom the cases were filed in the court and there were criminal cases against him. However, the Supreme Court did not decide the issue whether Tamil Nadu Services Maintenance Act 2020, 2002, sorry, 2002, and the Tamil Nadu Ordinance number 2003 were ultra vires or not. The decision not to take up this issue raises certain issues. Can the court refuse to determine the constitutionality of an ordinance or the act on the ground that most and not all workers are likely to be reinstated? Or whether the employees who have not been reinstated under the agreement should become illegal often? What would happen to those employees who would not be, who were not reinstated? Quite apart from this, the Tamil Nadu uh, ordinance also raises the issue: can a post facto amendment be valid? Is there practical relief provided to certain employees be a substitute for alleged illegal act of Tamil Nadu government? Can the order of dismissal under the act or ordinance, which is itself questionable, be sustained? Having discussed this, we come to the another issue. And the other issue is use of clinical modes like moots, mock trials, debates, legal aid clinic, etc. And what is the utility of the same? Let's take a case of legal aid clinic. Legal aid clinic, in my opinion, serve the purpose of providing legal advice not only with the aim of earning profits, but to help the clients who are unable to engage lawyer due to poverty or other reasons. In law schools, practical knowledge should be imparted to students to handle cases, to deal with labor cases such as suspension, withholding of increments, transfer or dismissal of employees for which the poor workers approach the clinic and seek legal advice. This, in my opinion, would provide an insight and practical knowledge to students for handling labor matters. Law teachers are required to help the students to deal with the cases. Law school may also invite advocates dealing with the labor cases to help the students. Here I wish to draw your attention that long ago I wrote an article which was published in Kurukshetra Law Journal on legal aid to the industrial workers. Having discussed this, one may come to the question of debates, that what should be the topic of debate, what should be the topic of moots. And here I feel that we may have a debate or moot on the question whether contract labor system should be abolished, whether social security be guaranteed and brought under the fundamental rights, whether the right to strike be included under Article 19(1)(c) or 19(1)(a) of the Constitution, or whether the provisions relating to occupational safety and health be applicable to all establishments irrespective of the number of employees employed therein. Quite apart from this, in several institutions, in addition to the lecture, there are tutorial classes. The law schools divide the students of each section into small groups where the teacher discusses various issues in the class and resolve the difficulties and issues raised by the students. Having discussed the debate, moots, and mock trial, it is necessary also to provide and to assign some topics to the students so that they can do some research or they may take up the legal writing. For this, I would prefer to provide certain instructions to them on the topics which are given to them. And I would like to tell them, number one, to formulate the legal issues, then to find out what are the statutory provisions which is applicable, to find out the relevant case law on the issue. Then I'll suggest them to use digest of reported cases to find more cases. They may be asked even to find out the relevant ILO conventions and recommendations. And when it confines to a particular topic, I will also suggest them to look to the labor code, namely the Industrial Relations Code, Code on Wages, Code on Social Security, and Occupational Safety, Health, and Working Conditions Code, which may be available on the net right now. Then I will ask them to find out the recommendations of National Commission on Labour and other commissions. And after having discussed this thing, I will suggest them to consider the national policy or the socio-economic and political considerations involved in such issues. And then they may like to consider what is the effect on industrial relations. Now, regarding if I allot them a topic relating to case comments or case law, I would like to provide them certain briefs, namely, I will tell them that what should be the component of case. The first one is they should discuss the facts. Then they may discuss the contentious issues, the holding. Then maybe reasons, say they may discuss the reasons for arriving at such decision. And then I will ask them to find out what is the policy underlying the judgment, such as social and economic policy. Well, let us take a case of sexual harassment or employment of children or girls, or say bonded labor or contract labor. They have to find out what is the social and economic policy. And suppose one doesn't find this policy being reflected in the judgment, I will ask them to consider that what social and economic policy were relevant in the judgment, which the court did not consider. Well, then here you can find a number of articles which have been written by me, namely the Supreme Court and Labour Relations, a critique of Gujarat Steel Tubes Limited, which is published in the Indian Law Institute Journal. Then we have the effect of non-publication of industrial awards, which is again published in the Journal of Indian Law Institute in 1958. And then we have the implications of withholding the publication of industrial awards. Suppose I ask them a book review. The guideline which I would like to provide to them, that while preparing or while writing a book review, they have to mention the title of the book, the name of the author of the book, publisher's name and address, pages, price of the book. Then they should give a general introductory remarks about the book and topic. Then critical analysis of each chapters. And lastly, they will look to the general remarks. If you wish to find out any book review, I would again mention that Professor Upendra Bakshi wrote a book review of my book on industrial relations and labor laws, including labor laws on social security and minimum standards, which was published in 2020. Quite apart from the aforesaid measures, there is a need to invite the experts or practitioners for labor lecture sessions. Fellow labor law teachers, we have miles to go. However, I feel that the aforesaid suggestions emerging out of my teaching and research experience over the last 5 decades would enable you to achieve the goal of excellence. I wish you a bright future.